Guns at the ready.
Scared, Potter.
You wish.
Hi everyone, this is Joseph Zhang. I'm the managing partner here at Zhang & Associates. We specialize in solving legal problems with creative solutions. Now, today's video is about how Harvard and MIT won against the Department of Homeland Security. This is a huge victory for the international students. I'm going to dive into the legal arguments on both sides. I just had to make this video because this lawsuit resembles so much Harry Potter, with Harvard and MIT representing Hogwarts and the Department of Homeland Security, ICE, representing the Ministry of Magic. So many similarities. Let's dive into it. To catch you up to speed, the issue in this lawsuit is whether or not international students need to attend class physically in order to maintain their non-immigrant student status, okay? So Harvard and MIT sued the Department of Homeland Security over whether or not they need to. Because on July 6th, right after July 4th weekend, they made a declaration saying international students must attend class. They cannot just do online classes. Now, this is a drastic change from their March directive saying, given the situation with the pandemic, it's okay to attend online classes. Harvard and MIT is suing the government, and it's based on 3 different laws that they violated. And think of it like spells. Spell number 1, violation of Administrative Procedure Act. Harvard and MIT basically argues that this decision did not take important aspect into consideration when they made this July 6th directive. They did not take into consideration the effect on the students, the schools, public safety, all these other very important things. And most importantly, it did not take into the consideration of reliance. The schools relied on their March directive in saying that students can take classes virtually, and they took months and months to plan out for thousands and hundreds of thousands of students, and then suddenly, when the moment's notice, they changed all of that. So they did not take into consideration really important facts. That's why this decision is arbitrary and null and void. Spell number 2, another violation of the Administrative Procedure Act. If an administrative decision is arbitrary, it's null and void. In order for it not to be arbitrary, you must have a good reasonable basis in making this decision. Harvard and MIT argues that the Department of Homeland Security did not make a well-reasoned argument on why they made this particular decision. Now, it's not so much that they didn't agree with the decision, it's there's no reason to support why they made this decision. Give us a coherent argument on why it is important for international students to attend class physically given the pandemic. Spell number 3, failure to give notice. So the Administrative Procedure Act requires that if you're going to make a rule, you need to provide notice and comments for this rulemaking. You just made this decision willy-nilly, and then within a month, it's going to go into effect. The public, interested parties had no opportunity to provide comments and discussion. So that's why this decision is also null and void. So those 3 arguments sets the stage for this entire court battle. Now let's see what the Ministry of Magic, or let's see what the Department of Homeland Security has to say in response. Now, before going into the actual arguments of the Department of Homeland Security, it's actually super fun reading it because it's exactly like what Ministry of Magic would say in response to Hogwarts.
No recollection of the incident whatsoever. So,
in essence, the first few pages, they respond with, let me teach you the law. In order to file an injunctive relief, you have to prove these 4 points, and you didn't mention them. It's kind of like you're in your tower of scholarship and you're too outdated. We deal with this day in and day out. Let me teach you the law, Professor Dumbledore. In order to win this injunctive relief canceling our directive, you must prove 4 things, if you forgot. Number 1, you must prove that you're likely to win on the merits of the case, which you are not. And number 2, you must prove that you will suffer irreparable damage if this injunction is not issued. And number 3, the harm outweighs the damage caused to us, the government, in making these decisions. And number 4, that the injunction is not against public interest. Let me dive down and argue each one in depth. Number 1, you are not likely to win on the merits of the case. In the entire attorney brief, Harvard and MIT continuously argues why the Department of Homeland Security's rationale is arbitrary. They did not consider it. They did not provide argumentation. They did not consider important facts. Well, the Department of Homeland Security provides, well, we've been discussing this since January. Look at these frequently asked questions we issued. Look at all of these decisions that we made prior to this decision. It was not arbitrary. We took half a year to decide it, and there's multiple agencies that are all deciding it, and it's not just us, and we finally issued this rule. So it was not arbitrary. We actually thought it through. And another reason why Harvard and MIT's argument will fail is that we are not subject to the notice rule. An agency only needs to provide notice if they're making a law. We are making a discretionary decision, which is not subject to the notice rule. You forgot that, Harvard professors, but let me teach you. Now you know. All right, the second point. You must prove that you will suffer irreparable harm if this rule goes into effect. We are just saying students need to attend class. This has always been the law. It's been the law for 20 years. We're not changing the law. We made a decision that allowed for them to take online classes temporarily while there's a pandemic, and now we're going back to the law. We're just enforcing the law. We're not making a new law. And how are you suffering irreparable harm? Students can take classes here in the US. You could take classes overseas. It's important that international students need to be physically in the classroom. The law is there, and we're just enforcing it. You did not prove why you will suffer irreparable harm. Harvard, MIT, are you concerned that you will suffer irreparable harm because there will be less students? I'm pretty sure there are other students that are willing to pay tuition to go to your school. Are you saying that the students themselves will suffer irreparable harm? No, they could just take online classes. We're not saying you have to cancel their degree. We're just saying they cannot have the visa to stay in the US because the law requires it. And number 3, Harvard and MIT, you cannot sue us on behalf of the students. If they want to sue us because they didn't have their status, then they could sue us. You cannot just go sue for them. If you want to sue us, then you can sue us. And it would be against public interest if the governing body of the United States government has to constantly check with different interest groups, like different student groups, to see whether or not our rulemaking would somehow affect them, and I get their comment first. We need to protect the US, so we need to make this decision, and this decision should not be null and void. Bam. Excited yet? That is the oral argument that sets the stage for today's oral arguments before the court, okay? So those are two sides. Now, after the government issued their reply, Harvard and MIT went like, you gotta be effing kidding me. So Harvard and MIT requested that the court allow them to issue a response to their response. And it's super interesting. Let me go into it now. First, Harvard and MIT argues, you still did not provide us an articulable reason why your decision is justified. You keep on saying that the situation is fluid, it's crazy right now, but that doesn't justify why you made this decision. Why stop the students now? Why not stop in December like the original plan? Or why not stop it next year? Or why not change the whole system altogether so that online education is fine? You made the decision now, justify, tell us the reason. We're all ears. You can make it up as long as it's justifiable, but you still didn't justify it. You can't even come up with an argument. I'm giving you an opportunity and you still can't do it. Therefore, it proves that it's completely arbitrary, and that's why it's null and void. And number 2, we cannot sue on behalf of our students, but we can sue. Then what's the point of that argument? Then we are suing you, right? Harvard and MIT is like, then that argument is completely null. Why even mention it? And by the way, we can sue on behalf of our students. These students are completely vulnerable. They're not gonna sue the US government if their visa is denied, then their visa will be forever denied, right? They're the very vulnerable group of people. So us, as the education of mankind, we are stepping in to help them sue you because your rule is unjust. And the best part of this response is, in the end, Harvard and MIT cites all these amicus briefs. All these cities and states and other universities and interest groups are all joining together, providing their argumentation on why this rule should be null and void. And it's like the Avengers, where everybody's coming together and fighting this final battle. It's super awesome.
On your left.
So that pretty much sets the stage for today's oral arguments. And before the oral arguments were really made, the administration pulled the directive. So instead of having a court cancel out their decision like what the Supreme Court did with the DACA issue, they just rescinded it. And so now all the international students, as of right now, can still take online classes based on the original March directive, allowing them to do so given the situation with the pandemic. And so if you take online classes and you're not doing it physically in school because school is shut down for some reason and they don't have a hybrid program, it's still okay until another directive comes out. And if it has a good articulable reason, then it might still go forward. But it's already July and August is around the corner and school is about to start. It might be too late for them to do that if they want to do that. So we'll see. And hopefully a vaccine will come out soon. Everybody pray for it. So that's it for this video today. I love doing these type of in-depth case analysis. It's super interesting because this is what the best can do, right? This is what Harvard law professors, MIT professors, this is interest groups spending millions and millions of dollars arguing these cases. This will have the ability to shape the entire nation. And this is the best of the government. Their argument is not some willy-nilly random journalist making an argument on Wall Street Journal. This is the actual government hiring their best attorneys, defending them why their law is in place, and this is what we got. So those were the best arguments from both sides. If there's anything that you think they missed, or if there's any public policy consideration that really should be taken into consideration, please let us know. We'll love to dive into it. We'll continue to make videos like this. If you enjoy it, please like and subscribe. Thank you. Bye-bye.